This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning to everybody who's decided to tune in to have some fun with a lawyer. Is that an oxymoron or what? Anyway, I now can't even hear from the headphones. Before it was too loud, now it's nothing. To the station manager.
Well, that's because your mic is not. No, I
Anyway, so I'm Stuart Address, and this is Ask a Lawyer. Yeah.
You can hear now.
Yes,
okay.
I can hear now.
Yeah, so that's back to normal. Okay.
October 11th. And, as I like to do, I like to start the show with some irrelevancies, and sometimes they end up turning into the whole hour. I do have a topic. But
irrelevancies like D.C.?
Like D.C., absolutely.
Hey, let's hear it for our guys, by the way. Two guys that got busted yesterday.
Yes, I'm leaving on a one-way ticket to countries without extradition.
Yeah,
that doesn't sound guilty at all.
They're local Palm Beach guys.
And
congratulations.
Of course, they were meeting with Giuliani just a couple hours for lunch at the Trump Hotel in D.C. before they tried to get on a flight at Dulles. Oh yeah, I'd like to hear the Republicans call now and tell me. Why are you being so mean? That's so innocent. Yeah, right. All right, that wasn't my topic.
You fly on one-way tickets, don't you?
Only if I have a lot of money. I'd rather get a round-trip ticket and then not use it because it's less expensive than buying a one-way ticket.
Okay.
Anyway, I walked in here today. Well, Cliff was involved in his swap shop. And I guess I walked in at an odd time. And I'm a little curious. The $5 vibrator, was that used?
Oh, wait a minute. Oh.
Don't answer that. This is not that kind of show. Don't answer that. This is not that kind of show. And if you're selling used vibrators for $5, you may want to ask a lawyer.
You get more than that.
All right, now number two. As our lovely station manager Greg walks in, he decides to be funny, as Cliff is talking about Stuart M. Address. Let's get ready to rumble, and Greg makes a comment that he was so gracious to repeat to me while I was tape recording him. So let's take a quick listen.
Oh no!
Oh no!
Stuart M. Address, the M for marijuana.
Now, I wonder, folks, what do you think? Let's do a poll. Is that slander? Implying criminal conduct on my part?
It's not criminal.
I don't know. I think you should give me 6 months free or something. We might need to negotiate.
Oh, no.
And I got a good lawyer for myself. So,
do you really?
Yeah.
Okay.
All right. Enough of this frivolity. These are serious times meant for serious men. I think that's a line out of West Wing. No, the American president. That comes out of the American president.
I think our forefathers said that.
Well,
They would say that if they were thinking of today.
They talk about what was the intent of the framers, and, would they roll over in their graves? I'd like to think that they'd be rolling over, standing up, and marching on the White House. That's
little break dancing, maybe?
That's my opinion. And of course, there's a very nice listener of the show, a truly nice gentleman who, on occasion, happens to come to the synagogue. I won't say anything more about identity other than that. And on Rosh Hashanah, we're done with service. We're having our oneg, which is our little, grape juice, challah, some brownies, some cookies, that kind of stuff. And he wants to engage me in a dispute over something I said on the show regarding Mr. Trump.
Oh, no.
And I just had to say, no, not today. Not on this holiday. I am not going there. But if you'd like to engage me at any other time, I'd be happy to engage. If you want to call me now and tell me how foolish I am, like another caller I think did the last time I was on the show, that's okay too.
Yeah, you got slammed pretty bad there.
Yeah, I wonder if, is any of that slander? No, not really. It's their opinion. First Amendment, lovely thing. It's just a shame that somebody doesn't understand it. Particularly freedom of the press.
What?
There's this thing called freedom of the press.
Oh, okay.
This thing that is absent in most dictatorships.
There is a press now?
Supposedly, I guess I love to deviate. Supposedly there's this outroar in China now over the statement of the Houston Rockets owner, which is a belief held by very many, that Taiwan should be free.
Free Hong Kong.
Right, free
Yeah,
Hong Kong.
you bet.
And, the Chinese took offense to that because there's a scheduled date on when they're going to resume total control. And, okay, the NBA commissioner was a little wishy-washy trying to walk a tightrope. And then you had the New Jersey Nets owner who has a big business in Hong Kong and is from that area, who speaks out, against the Houston Rockets owner. And now, they're saying, well, they stopped all the press conferences, but they're boycotting in China, and the 1.5 billion people are up in arms. And I saw a great article this morning that essentially said, excuse me, that is not a democracy. The people don't even know what's going on. The state controls the press. They know what the state wants them to know. And therein lies the problem. You cannot have an honest, informed opinion on anything if the only information you get is from the state. And so most democracies believe in freedom of the press. Well, they all do. Some of them put some limitations on it. There are different countries that have different founding principles. Even England put some limitations on freedom of the press in terms of prior restraint. We don't. It's an absolute. Now, can you be punished for slander? Can you be punished for incitement to violence after the fact? Absolutely. There are consequences if you violate other legal principles, but you can't be restrained. When the New York Times published the Pentagon Papers.
Yeah, I remember that.
There was a big battle to restrain that publication on national security. And the Supreme Court wouldn't do it. Now, there are some times that, the White House, in all administrations, will go to a publication that's about to publish something, get some advance notice maybe for a comment, and, they'll be, please hold off, don't publish, or give us a week or whatever. It's a matter of national security. And, of course, right these days, that's taken with a joke, national security. But there are times where publications choose voluntarily to refrain from publication, whether it's for 24 hours, 72 hours, whatever, because, the president says, off the record, we're going to have a strike tomorrow. We don't want you publishing this. Okay? And they rely upon the press's discretion not to now publish their own article. And by the way, we're having a strike tomorrow. And when you have not a symbiotic relationship, but a professional relationship, it can work. When one side or the other, and I will, come down on the press side too. When you have one side or the other, the president doesn't respect the press, or the press doesn't respect the president, you can get into going a little bit too far, and you have problems.
There was an assistant news director that Carol worked for at NBC in L.A., and he said, the one word, if I hear anybody utter advocacy journalism in this newsroom, you are fired.
That's all it is now.
That's it, on both sides.
On both sides.
And I remember going back to the Stone Ages of black and white television almost, when I was a Capitol correspondent in Sacramento with Jerry Brown as governor. And the governor used to have this little coffee klatch, if you will, in the afternoon, except it was beer, on Thursdays. And there were 8 of us.
Jerry Brown, you sure it wasn't marijuana?
No, it was beer. But it could not happen today. It was just him. His advisor wasn't there, and there were 8 of us, 2 in television from San Diego, 1 from L.A., and then 2 newspapers. And he would say what's going on for the next week.
It can happen now.
I don't think so.
I think it does happen in various cities and communities where there is at least a professional respect.
You may be right, yeah.
But I agree with you. It doesn't happen on the national level. Sometimes it happens in campaigns.
But
where
when
they
you
go
say
on the
off
campaign
the
bus.
record,
It's off the record. It's off the record.
Yeah, and
The moment you violate that, it's like
done.
me lying to a judge.
Oh,
I lie
God,
to a
no.
judge.
You're
Every
done.
judge in the 19th Judicial Circuit is going to hear I lied to this judge, and I'm toast. If you violate off the record, you deserve to be toast.
Okay, what would happen in that situation? I mean,
There's no punishment.
and you move to another district. Does word follow you if you try something like
Oh,
that?
look, if I went all the way down to Miami or something, maybe it wouldn't follow me. But,
Miami, that's a whole different country down there.
but yes, it tends to follow.
Yeah, I'll bet.
Reputations are important.
Yeah, they are.
And once damaged, they're very hard to recover from.
Yeah, I'll
And
bet.
so that's why it's so important not to damage them, and that's why you have slander and libel and defamation laws. Of course, when you deal with public figures, we've talked about this on this show before. When you're dealing with public figures, these suits are very difficult. A public figure suing somebody for slander or defamation or libel has a hard time of it, very hard time, because they've got to show, intent, basically, to lie, or a reckless disregard of truth or falsity. It can't be negligent. So it's a much higher standard because you've put yourself into the public space. So I thought, for example, briefly, there was, I wish I could remember exactly what the statement was. I think Trump called Adam Schiff.
Mm-hmm.
He accused him of, I accused him of being a traitor or something.
Oh, God.
And I thought to myself, this is file a defamation suit. Doesn't matter that he's the president. A civil suit for defamation. Make Trump prove that you're a traitor. Truth is a defense. And I thought about it, and I said, from a strictly legal perspective, it is a good idea. Put him on his backside with a big lawsuit now and make him prove this. But, of course, the political distraction countermands that desire for me to see that type of a lawsuit filed right now and just pile on. And of course, I know we have lots of listeners listening to me who aren't even calling 340-1590 who think that what I'm saying is heresy, is sacrilege, is I'm defiling the good name of the best, absolutely the best. I tell you, he's the best president we've ever had. Just ask him. All right.
Well, you talk about that, and you think, okay, but think about all this impeachment stuff now. Have you heard a word about the debate next week?
No, you haven't heard a word about the debate. I thought you were going a different direction. You haven't heard a word about the debate.
But it's buried all those candidates.
Where I thought you were going was, have you heard a single word from a Republican who, and in the Senate, who is standing up and saying enough is enough? And other than perhaps Romney, you're not. And I've had discussions with many people. My frustration level is on overdrive because there are many times in the history of this nation where we've had all sorts of difficulties. And parties stopped being parties, and people started acting more like patriots.
Just being American.
Okay? Right, an American patriot. Now, it happened in Watergate.
Yes, it did.
Okay, Nixon resigned only because the Republicans told him, you're going to be impeached, and we're going to vote to kick you out. So if you want to have a graceful exit, you better resign. And that's how it happened. If the Republicans in the Senate, okay, in 74, had not told Nixon, you have a graceful way out or we're going to kick you out, this would not have happened. So I don't even, I remember a little bit from those days because I hated Nixon at the time.
Well, you were awfully young, though.
But I have since grown up and actually grown to respect some of his foreign policy.
Oh,
Okay?
he was amazing.
So you do evolve as an individual over time. But, without even knowing who they were, I admire those Republicans in the Senate who, on something really that is much lesser than what we have right now, because Nixon wasn't involved in the break-in. Nixon was involved in the cover-up.
Well, his USC buddies were.
Okay, but even I don't believe that he had knowledge in advance of the break-in. I don't believe it. Okay, with all the information that's been out in all 40 years, I don't believe it. I believe he decided to cover it up. And the Republicans at some point, 18.5-minute gap, and you start hearing what was on the tape. Said, you're out, buddy. Okay, and so every day when I listen to the news and I hear something new, I say to myself, particularly when it's egregious in my view, when he says, China, if you're listening, please help. Oh, yeah, a joke. Sure, China's going to take that as a joke. But, when I hear these things, I say to myself, where are the statesmen? Where are the senators that have been there for 20, 30 years, who have reputations, histories, who know that when they're gone, they're going to have a legacy of some kind?
They don't give a damn. They just want to get reelected.
It didn't always used to be that way.
Oh, I know.
Where are the
That's
ones?
why we need term limits.
Where are the ones that hear their own oath of office to defend the Constitution against all enemies, foreign and domestic, when you literally have somebody ripping up the Constitution? I know it's difficult. I can't imagine how difficult it truly is to be in that position. I can only imagine that it is really difficult. But where are the ones who start the bandwagon? Because it always takes one or two or three, and then they start coming. Where are they to say, the nation is more important, the Constitution is more important than party? And so I stand, and I will vote if it comes to me, blah, blah.
I think you're dealing with egos now. It's almost like sports. I hate to say it, but I mean, it seems that way.
That's sad.
Oh, I know it is. Yeah.
And so, in those situations, unfortunately, you can't ask a lawyer, although Trump is asking a heck of a lot of lawyers. Trey Gowdy's the newest one.
Yeah, you get fired at Fox, too.
All right, so let's talk a little bit about the Americans with Disabilities Act. How's that for a segue?
Well, you were talking about a disabled DC, so yeah.
All right, thank you for the good segue. All right. In our office, we really do get a lot of calls. It's not always from people who have the disabilities that you might think of listening to the show. It's not always from somebody who, has one leg, or is hard of hearing, or was injured overseas in the military. Those are certain types of disabilities. But they're by far not the only ones, and not even the most common in terms of the ADA. You have women that get pregnant. Pregnancy is not automatically a disability. But if you are having a difficult pregnancy, it does qualify under the ADA as a disability. And so you have certain protections. So we talked about the Family Medical Leave Act. That only applies to employers that have 50 or more employees within a 75-mile radius, and you have to have worked for at least a year and 1,250 hours. But if you're working for an employer that has 16 employees, and you just started 3 months ago, and all of a sudden you find out you have a difficult pregnancy and you need to be in bed for the next 2 months, you're protected under the ADA. Now, you may not be protected to get exactly the 2 months you need. Let's be, you don't just get. It's not a leave statute. It's a statute as to what can the employer do. Are there reasonable accommodations that could be made to help you deal with the disability and still be able to work? Now, sometimes that is a period of leave, and we're going to go into that. But it doesn't have to be. If you can't be on your feet, well, they can give you a desk job. That may suffice under the ADA. That's an accommodation. It doesn't even have to be the accommodation you request. It just has to be a reasonable accommodation that the employer offers that will solve whatever the issue is. So you have a car accident, not at work, you just happen to have a car accident one day. And you walk in with a broken wrist. And you're
tough to type.
Right. I don't know if they call them secretaries anymore. I know,
assistants.
Assistants. You're an assistant that does a lot of typing. You really can't type. Now, I didn't have a broken wrist, but I had a shoulder problem several years back, and I really could not type. I got myself the, speech-to-text software.
Sure.
It's a good one. I had to train it a bit, and I plugged it in, and, I dictated most of my stuff straight into the computer. Did I have to do some document cleanup, or did my assistant have to help me and do some document cleanup? Sure. But it enabled me to work. And just like it enabled me to work, even though I was my own boss, somebody who walks in with a broken wrist and, okay, you don't have to send them home. Maybe that's what they want, but they're not necessarily entitled to it. If you want to get them dragon speaking I said I wasn't going to mention any products. Oh my gosh. If you want to get them any of the software that, does speech to text,
you could do product placement on this show,
That may be a reasonable accommodation. And that's what the ADA talks about. So, initially what's important to remember is if you think you have a situation at work that requires some type of assistance, some type of an accommodation, you're not even sure whether it qualifies as a disability, because I'll tell you something. Sometimes lawyers have to research to see if it qualifies as a disability. So nobody would expect you to automatically know it. But you have a situation, you need some assistance. It does you no harm to make the request, because you have to make the request. Unlike the FMLA, the Family and Medical Leave Act, where if the employer has any reason to believe that you might need the benefit of that statute, it has to offer you the packet. The only statute of its kind that I know of. The ADA, you have to ask for an accommodation. If you don't ask for an accommodation and then you're fired because you can't do your job, you're not going to have a cause of action. You didn't even make the request for assistance.
Okay.
So now people will ask, I think, does that have to be in writing? No. Nothing in the ADA or in court cases say your request has to be in writing. Now you call my office, one of the first questions they're going to ask you, did you put it in writing? Why? It makes it so much easier for me to prove your case. You go to the Director of Human Resources and say, can I have this software because my wrist is broken? And they say no. Well, now it's a he said, she said. You want me to take this or any other lawyer on a contingency fee case basis in federal court? We may not do it, because if it's 50-50, who's going to be believed? I don't know if I want to put my time on the line for that. Most lawyers don't. On the other hand, if you show me that you sent an email to HR that said, I have a broken wrist. Could I, have 4 weeks off at home? And then they respond, no. But they don't say anything else, just no. You're fired. You have a claim. Why? Because they didn't do what they're supposed to do now. You asked for 4 weeks off. They are now, once you make the request, required to, investigate, look into it. The facts of every situation are different. Then they're required to engage in what is called an interactive process. That means they're supposed to communicate with you. Mm-hmm. And talk to you about your situation. Okay, you say you need 4 weeks off because you broke your wrist. Would you be able to do your job if we got you this software? Yes. They do it. They've satisfied their obligations as an employer under the ADA. You say, no, it wouldn't. I want to go home. And it turns out that really would have been a reasonable accommodation to get you the software. You don't have a case. Because even though you didn't get what you wanted, they offered you something which was a reasonable accommodation because it would have enabled you to do your job. Now, you break your back and you say, I need 4 weeks off because I need to be at traction. The only reasonable accommodation is probably the time off.
Yeah, well, you have no choice.
But do they have to give it to you? No. Because now we
Wait a minute.
No. Yes. Now we go into another part of the statute, which is in defining what is a reasonable accommodation, it cannot impose undue hardship on the employer. Now then, undue hardship has to be defined. And it is also defined on a case-by-case factual basis. There are guidelines in the statute. There are guidelines in the Code of Federal Regulations. There are guidelines in case precedent.
Now, again, this is 50 or more employees in, right?
15.
15.
The ADA is part of Title VII of the Civil Rights Act. Just like discrimination based on age, national origin, gender, race, disability. The ADA, part of Title VII of the Civil Rights Act. 15 employees.
Okay.
So they now have to engage in this interactive process. If they do it, and they propose a reasonable accommodation, and you don't want it, that's your problem. But what if there is no reasonable accommodation? Given that it would impose an undue hardship on the employer, then they don't have to give you what you want, and they don't have to give you anything. They could let you go. But now you're going to be suspicious, most likely. They could have done this for me. And, you call any attorney's office, hopefully you're going to get involved in a discussion about what was available. Were there any other positions they could have put you in temporarily? If you tell me, no, there was no other place they could put me, you're basically telling me you don't have a case. And that happened this week on the phone in my office. We had a prospective client who it seemed to me had a very good ADA case. And I thought that all they would have had to do, for a few weeks is put her away from harmful chemicals and, give her a desk job. And she told me that there was no other position in that company that she was qualified for. And I questioned her about it. And she insisted that, they gave her a mask. It was uncomfortable. Okay.
Which they are, yeah.
Okay, and she had some, emotional reactions to it. You get claustrophobic. I can understand that. I think I would too, frankly.
With just a mask?
Yeah, with a mask that completely.
Yeah, like one of the white masks. And
it all depends. See, they put. I was at the doctor's office recently, and I had a mild cough, and I've never had this happen before. This particular nurse must have been very. She made me wear a mask. One of those little, I don't know what they're made of, but nothing mask, just covers your nose and your mouth.
Yeah.
I couldn't breathe. I felt like I was breathing my own carbon monoxide. So I moved it up. And she walks back into the examining room, put it back on, please. And I was like, I'm uncomfortable. So once she left and the doctor came in, it was no big deal. Doctor wasn't afraid. And this nurse was. It was uncomfortable. And that's just a paper, little nothing. You
Yeah.
put one of these big giant apparatus when you work with chemicals, I can understand it. So when I'm questioning her, she insists that there was really no other position they could give her. In that case, I had to tell her, I don't believe you have a claim. There was no reasonable accommodation for you. The only one that existed, they tried. And you're telling me it didn't work. So I don't think the employer did anything wrong in that situation.
Okay, hypothetically, if they did have, say, a clerical,
Yes.
what about the pay? Because if she was getting X amount for this other job, clerical might be a hair less. Does she get the same pay?
No. Again, we're talking about reasonable. Reasonable is a two-way street now. Reasonable is it reasonable to the employee, and is it reasonable to the employer? You can't, I don't believe, ask an employer to pay you, double for a position because you had to leave a position was higher paying temporarily. I don't think you could do that. I mean, I haven't really looked at that. It's not a situation really that's arose so far in my experience, but I can see it arising. My instinct is I don't think so. But you do have to look at what is reasonable, what is an undue burden, very carefully. Now, if it's an undue burden for the employer to pay you $50 an hour for a $15 an hour position, I can understand that, because the courts talk about, what are, let's look at two things. Okay, we'll go to undue burden in a second. 3 major categories of accommodations that can be made. Modifications or adjustments to the job application process. You're applying for a job. You're blind and you can't read the application.
Ooh.
There needs to be a reasonable accommodation, otherwise you're going to have a claim.
Applications in Braille?
In Braille, or somebody to assist you.
Okay. Yeah.
Okay.
I see that. Yeah.
2, modifications or adjustments to the work environment. That could be the mask for the chemicals. It could be a scooter to get around. It could be somebody to help you if you have to lift more than 25 pounds. It could be the software to help you type. It could be a lot of things. Those are modifications to the work environment.
We had a young man, when Carol and I first got here 26 years ago, who was visually impaired. And what he had done with the audio board was put the commands in Braille
Okay.
above each audio pod.
Doesn't seem expensive.
And he was one of the best engineers we had. Yeah, it was great.
All right, and the third one is modifications or adjustments that enable the employee with the disability to have equal benefits and privileges of employment. So now, let's say you need a handicapped restroom.
Which we have here.
Okay. I will tell you something. Not all handicapped restrooms are created equal. There are lots of places that are grandfathered into old regulations that do not allow wheelchairs to move around in a 360 radius. They're more awkward. Somebody needs some modifications to the handicapped restroom. Now, the law doesn't necessarily require the employer to do that generally because they're handicapped, they're grandfathered in.
When we rebuilt this after the hurricanes in 2005, the county claimed that this was a public building, so we had to build that new one.
But let's say you're one of the older handicapped restrooms and you're not required to update And so there are things that aren't in there, maybe a grab bar, who knows what.
Right.
But now you have an employee that has an issue and they need an accommodation. Well, that is an adjustment, a modification to enable the employee to enjoy the same benefits and privileges. You may have to update your handicap restroom, even though you're not required to do it generally as a matter of law, but now you have a specific situation where it's necessary, and that could be the reasonable modification. Now, what if you're a small employer, 15 employees, and the modification is going to cost $50,000?
Ooh, ouch.
Well, that factor is taken into account as to whether or not it creates an undue burden. So we move on to that area of the analysis. Okay. We look at things like, well, here's the definition, first of all. Undue hardship, I say undue burden, undue hardship, means a significant difficulty or expense and focuses on the resources and circumstances of the particular employer in relationship to the cost or difficulty of providing a specific accommodation. A mouthful of a sentence. And what lawyers do is we break it down word by word. So, undue hardship refers not only to financial difficulty, but to whether reasonable accommodations are unduly extensive, substantial, or disruptive. Do you have to do something that is going to require jackhammers for a week and disrupt your entire operation? Well, no, I'm going to tell you that's not going to be a reasonable accommodation. That's going to create an undue burden. Okay?
Sure would here.
So, key factors of undue hardship. The overall financial resources of the employer. Okay, you look at that. The type of operation of the employer. What does it do? What are the number of employees? What would be involved in creating the accommodation? What disruption might it cause otherwise? And you flow into that with the third factor, which is the impact of the accommodation on the operation of the facility. Okay? So, like we were talking about, if it's going to essentially, this is a radio station. You can't have jackhammers, in the hallway knocking down walls while you're trying to run radio programs.
And we have 2 live studios.
Okay, so if that is what was going to be required, it is not a reasonable accommodation because it creates an undue burden or undue hardship on the employer. So you're looking here at both sides of the equation. You're looking at what does the employee need, not what they ask for. Okay? As an employee, if you need a reasonable accommodation, there is no harm in you or your doctor coming up with what you believe would be a reasonable accommodation and proposing that to the employer. Nothing wrong with that. But the employer does not simply have to say yes. The employer has to talk with you, try to figure out whether that's necessary or something lesser will solve the problem. And whether it's that or the lesser thing, does it create an undue burden? And it's not just the employer saying, oh, that creates an undue burden, and, goodbye. That's not the way it works. Employer says, oh, that creates an undue burden, and you call a lawyer. Hopefully that lawyer is going to say, okay, well, what was the undue burden? What was the employer complaining about? And if it doesn't sound kosher, that leads us into Ask a Rabbi in a little while.
I was going to say, nice promo.
If it doesn't sound kosher, likely you're going to have an attorney looking at the possibility of starting with a demand letter and maybe moving into litigation. Because if the employer just says, oh, undue burden, because it doesn't feel like doing it, well, that's not going to cut it.
But if it's something that is not a major construction project that may be able to be done on like a weekend.
That's right. Now you look at let's say what's the cost? Mm-hmm. Is the cost unreasonable when you take into account the size of the employer, the net revenue, the number of employees, how long the accommodation is necessary. It may not be reasonable, maybe an undue burden. Maybe then the best thing is to, give that employee, 4 weeks leave. So let's go into the leave aspect of the ADA. You come in and you ask for leave. I've already said you're not automatically entitled to it. But that doesn't mean you're not entitled to it.
Oh, come on.
This
You
is-
are splitting hairs.
This is what gives me a job. And if we have time at the end, I will tie this all up with a little story that I had to engage in with my son last night in preparation for his first debate tournament tomorrow. And you'll understand why lawyers learn to speak out of both sides of their mouth. And that's not a bad thing. Hopefully I can explain that. So, all right. Permitting the use of accrued paid leave, if you have accrued paid leave, is a form of a reasonable accommodation.
Okay. Yeah.
What about permitting the use of unpaid leave? Well, maybe. If that employer now has to hire a new full-time employee, does he then have to fire that employee in 3 weeks? That may not be reasonable or fair. So we're going to look at that. Now, what if you want, let's say you have 4 weeks of paid leave. You want your 4 weeks paid leave, and then you'd like another 2 weeks of unpaid leave. All right, so we have to engage in the interactive process as to whether this is reasonable. However, an employer does not have to provide paid leave beyond that which is provided to similarly situated employees. So you don't get something extra.
That the other employees don't
That's
get.
right.
Yeah. Yeah. That makes sense.
The other thing, if leave is permitted, now the question becomes, we've just touched on it, must the employer hold that position open?
Wow. Yeah.
The answer, if you permit leave as a reasonable accommodation, yes. An employee with a disability who's granted leave as a reasonable accommodation is entitled to return to his or her same position unless the other side of every legal question, unless the employer demonstrates that holding open this position would impose an undue hardship. And we've already gone through how do you look at what's an undue hardship. Now, what happens if the employer gives you the leave but can't hold the position open? Well, if the employer can't hold the position open during the entire leave period, then the employer must consider whether it has a vacant, equivalent position for which the employee is qualified and to which the employee can be reassigned to continue his position within the company. So, maybe they can't give you your job back. But if they have an equivalent position, they have to put you into it if they've given you leave as part of the accommodation. Slightly different than the Family and Medical Leave Act, where when you come back, you must be put into your exact position or a substantially equivalent position. A little different, maybe not completely different here. Here, if you have the open position, they have to. Under the FMLA, they simply have to. They better have a position. Your position or something that's substantially equivalent. That means salary, duties, responsibilities, opportunity for bonuses, opportunity for advancement. Under the FMLA, all of that goes into, is it a substantially equivalent position? Matter of fact, I litigated that very issue in the old Fort Pierce Federal Courthouse, the bank building, oh gosh, I don't know, maybe 5, 7, 8, 9 years ago. A 2-week trial, and we won. Because a certain bank, Seacoast, didn't do what it was supposed to when an employee came back from FMLA. Now, if leave is requested by the employee, does the employer have to provide it instead of an accommodation? We've sort of already answered that. The answer is no. If another accommodation will suffice, then the employer is well within its rights to offer that as the reasonable accommodation. Okay. Modified work schedule? Yes, that could be a reasonable accommodation. Working from home. If the position is such that you can effectively perform the essential functions of your job, doing it at home, that could very well be a reasonable accommodation.
Wow, I'd like to figure that one out.
Okay. Let's say you're a probationary employee. Does that matter? No. Unlike the FMLA, where you have to have been there for a year and worked 1,250 hours to be eligible, here the requirement is simply 15 employees for the ADA to apply. You can be there a week. If something happens, you're entitled to relief under the ADA. And if that relief is available as a reasonable accommodation, the employer has to give it to you.
Just like any of the other employees.
Just like any of the other employees. Now, when you return, you may still be on your probationary period. You know, the 90 days doesn't run just because you were at home relaxing, sipping, pina coladas.
Wait a minute. So that would start all over again?
No, I think it would start if you had to, let's say, go out on leave on day 6 of your 90-day probation.
Yeah.
I think you come back on day 7.
Okay, I got you. Yeah.
Okay?
That makes sense.
Now, let's talk. We did really good on this ADA. Let me talk one last thing on burden of proof and then try to tell a really quick story. The burden of proof in the ADA, according to the Supreme Court, the plaintiff employee need only show that an accommodation seems reasonable on its face. For example, ordinarily or in the run of cases. Once the plaintiff has shown that the accommodation he or she needs is reasonable on its face, the burden shifts to the employer to provide case-specific evidence proving that the accommodation requested would cause an undue hardship in that particular circumstance. So you have a shifting burden. It's similar to discrimination, which is called a McDonnell-Douglas test, where you have an initial burden that's a low burden to show. The employer then has to respond and meet a certain burden to avoid summary judgment. And then you may have to respond to dispute the employer's response, show it's a pretext. And then it's up to the jury to figure out. But I will say, yes, this can be complicated. And that is a perfect reason as to why you should consult a lawyer. Now, one of the things I will admit that frustrates me, and I should say we now have a brand new paralegal in our office. And I didn't say it before, but give Sadia a call at 781-8003. That's S-A-I-I-D-I-A, Sadia. She likes to say Sadia like Nadia.
Okay.
Helps me remember it. Very lovely new paralegal. I have wonderful hopes. She's so far been a little bit like a week or so, given the Jewish holidays and everything. And she comes to me from a judge. So she's been on the other side.
Oh,
I'm hoping to get interesting insight as to what judges are looking for. So anyway, give Sadia a call with any questions you may have, and maybe you have a case. But these things can get complicated. One of the things that troubles me, and Sadia has already seen it this week, in coming to me with people who call the office, and we go through it, and I try to decide whether there's potentially a case or not. And somebody says, well, I had this issue. The employer didn't want to do it for me. I resigned. Now they're calling me. And I throw up my hand. Why? Why don't you call me before you resigned? Maybe I could have helped you. Or, they have some other problem and they take other precipitous action before they ask a lawyer. And you preclude some of your options when you may do that. I do a lot in the employment context, in the discrimination context, civil rights, particularly employment. If something happens that you think is amiss, that you think is violating or should violate some right that you have or should have, you really should ask a lawyer. The worst that happens is you're told that unfortunately that's not the law, and you have some insight. But you may be told, okay, send a letter to HR, say this, so that if they don't give you what you need, then call me back. And now you're better protected if they don't do it, and maybe you never even need me because they get your little email and they do the right thing. So whatever it is, it doesn't cost you more than a dime. It doesn't even cost you a dime anymore to pick up the phone and ask a lawyer. But to do so after everything is, as I say, fait accompli, it's over, done with. You may have given up your rights, and that's a shame.
Data fees do apply. Oh.
Yeah, that's right. Now, okay, in 2 minutes, my son is debating in his first tournament tomorrow.
Cool.
He has to debate the same resolution, 2 times affirmative, 2 times negative, 2 times in favor, 2 times against. So he had to prepare his affirmative and his negative. So on the resolution of standardized tests ought not be used in the admissions process.
Ooh.
He has to come up with his best arguments as to why they should not be used. He has to anticipate what is the negative going to say as to why they should be used. And he has to be prepared to respond. Now, when he's negative, he has to argue that they shouldn't be used. And he has to anticipate what the affirmative is going to say as to why he has to argue they should be used. And he has to be prepared to argue what the affirmative is going to say they shouldn't be used.
Wow, that's cool.
So now, what does that do for you? It teaches you to look at both sides of an equation before you take a position, except in a debate where you're forced to argue one side or the other. It forces you to try to analyze what the holes might be in your own arguments, because you're looking how to defeat your own argument.
Sure.
And arguing 2 affirmative and 2 negative in one day's debate is speaking out of both sides of your mouth. But it's not bad. It's training. It's training to be an intelligent citizen who can analyze things for themselves and not be sheep. So that's Ask a Lawyer for this Friday. I hope you enjoyed our little discussion, and I'll be back next Friday. And in comes, well, not quite just yet, but pretty soon in comes the rabbi. Have a good week, have a good weekend, and I'll talk to you again next Friday.
And good luck to your son this weekend,
Thank
huh?
you.
All right. Stuart M. Address right here on WP.
M is not for marijuana.
WPSL Port St. Lucie, WPSL.com, webcaster to the world.